Good morning, this is your Kelso Report for Tuesday, July 24th, and I'm your host, Clark Kelso. We begin with a professional responsibility case out of the Ninth Circuit where an attorney was sanctioned. So everybody listen up. The District Court in Haynes v. City and County of San Francisco found that counsel continued to pursue claims against government defendants for excessive force and involuntary detention, even after it became clear that the claims were frivolous and in bad faith. The District Court imposed sanctions on counsel under Section 1927 of Title 28 in the amount of $360,000 for excess costs and fees incurred by the defendants because of counsel's misconduct. The court refused to consider counsel's assertion that he was financially unable to pay the sanctions, apparently believing it had no discretion under the statute to reduce the amount of sanctions. Well, the Ninth Circuit reversed, holding that a district court may reduce a Section 1927 sanction award in light of an attorney's inability to pay. So the case was remanded to the district court for consideration of whether to reduce the sanctions award. We have a death penalty case out of the Supreme Court of California. In People v. Thomas, a jury had convicted the defendant of the first-degree murder, of kidnapping the murder victim for the purpose of robbery, of robbing her, of forcibly raping her, and forcibly sodomizing her. As to each of these offenses, the jury found true sentence enhancement allegations that a principal was armed with a firearm, and as to the rape and sodomy charges, the defendant acted in concert with an accomplice, and that the defendant kidnapped the victim for the purpose of committing the offenses. The jury also found true 4 special circumstance allegations: that the murder was committed during the kidnapping for the purpose of robbery, rape, and unlawful sodomy. The jury, not surprisingly, returned a verdict of death. The Supreme Court on automatic appeal unanimously affirmed the death penalty in a 49-page opinion. We now have 725 inmates on death row in California. Let's turn to a labor law case. The issue before the 2nd District in Harris v. Superior Court, which was on remand from the California Supreme Court's decision in Harris v. Superior Court, 53 Cal 4th 170 in 2011. The issue was whether certain claims adjusters for 3 insurance companies were entitled to overtime pay under California law, or in the alternative, whether they were properly classified as administrative personnel not entitled to overtime. Applying the legal standard adopted by the California Supreme Court, the majority held that, with only a few exceptions, adjusters' work duties do not satisfy the so-called qualitative component of the directly related requirement, because they are not carried on at the level of policy or general business operations. That is, adjusters are not primarily engaged in work that is directly related to management policies or general business operations, and it therefore follows that adjusters are not exempt administrative employees under the applicable state wage orders. Next, in In Re Christian P., the trial court had declared 2 sons to be dependents of the court based on findings made pursuant to Section 300B of the Welfare and Institutions Code. The boy's mother appealed, contending that the trial court erred in ruling that the Department of Children and Family Services need not comply with Section 827 of the Welfare and Institutions Code before using and disseminating evidence from an unrelated dependency case, and in admitting such evidence in her case, and that the evidence was insufficient to support the trial court's jurisdiction finding that the children suffered or were at a substantial risk of suffering severe physical harm or illness. Now, Section 827 expressly permits attorneys for the county to access juvenile court records without a court order in order to handle the cases to which they have been assigned. The 2nd District held that this unrestricted authorization applied here, so that counsel could access juvenile court records generally. The 2nd District also held there was adequate evidence to support the jurisdictional finding. The department in this case had conceded that the trial court erred in sending out required notices under the Indian Child Welfare Act, so the court remanded so that the trial court could follow the inquiry and notice provisions of the Indian Child and Welfare Act and then for further proceedings as appropriate. Interesting attorney's fees issue. The plaintiffs in Volgamuth versus Caterpillar purchased a new motorhome that had an engine manufactured and warranted by the defendant. The plaintiffs claimed the engine was defective and sued defendant under the Song-Beverly Consumer Warranty Act, alleging the defendant failed to repair the defects after a reasonable number of attempts. Shortly before trial, the defendant made a Code of Civil Procedure Section 998 offer to compromise. The offer provided that plaintiffs would be paid $50,000, in exchange for which plaintiffs would dismiss the action with prejudice and sign a release of all claims. The offer was totally silent as to attorney's fees and costs. Plaintiffs filed a notice of acceptance of the offer, dismissed the action with prejudice, and then moved to recover their attorney's fees and costs under Section 1794D. Defendant opposed the motion, arguing that there was no formal judgment in plaintiff's favor as a predicate for an attorney fee or cost award, and that in any event, defendant was the true prevailing party, not the plaintiffs, since a dismissal had been entered. The trial court rejected defendant's arguments, found that plaintiffs indeed did prevail, and awarded attorney's fees and costs to the plaintiffs. The Fifth District rather easily affirmed. As for the absence of a formal judgment in favor of the plaintiffs, the court noted correctly that the word judgment, as applied in the context of Section 998, has been given a rather broad interpretation that refers to any type of final resolution of the case. And the fact that there was a dismissal of the plaintiff's action certainly did not mean the defendant was the prevailing party. The trial court correctly looked at the actual reality of the situation, and given a $50,000 recovery by the plaintiff, it was pretty clear in the circumstances that the plaintiffs actually had prevailed. That's it for today's Kelso Report. Have a great day in the law.